So mortgage is uh, as per the definition defined in section 58 of the Transfer of Property Act. Mortgage is a transfer interest in specified as immovable property for the purposes of security payment of money advanced or to be advanced by way of loan or for the existing debt of the company or future debt of the company or the performance of an engagement which may give rise to a pecuniary liability. So as per this, mortgage is a legal process where a person borrows money from another person and secures the repayment of the amount due to the company with interest as agreed upon with the company by creating a charge over the assets of the company, whether movable by nature or tangible by nature. So this is a definition as per the uh, Companies Act 2013 or as per the Transfer Property Act. Uh, the definition is given in that particular act about the term mortgage. Then come to the term charge and mortgage. A mortgage and a charge, the former being a transfer interest in immovable property as a security for the loan, whereas the later is not a transfer, so it is nonetheless a security for the payment of an amount. So mortgage and charge, the former being a transfer of an interest uh, in immovable property that is tangible by nature, in the form of security for the purposes of obtaining loans and advances from the banks or financial institutions. So the mortgage and the charge being a transfer of interest, because you have to transfer interest in that property till you pay the final amount, due amount to the banks or financial institution with interest, and uh, uh, the banks can release your property. Now you can, after release of your property from the banks or financial institution, then you can sell, resale, uh, or uh, use the property, dispose of the property uh, as per your uh, as per the directions of the company, but not before. Uh, there's a difference between charge and mortgage. Uh, the mortgage is a transfer of an interest in your property as security for the purposes of loan. But charge is security for the payment of the amount due to the bank with interest. Mortgage deed includes every instrument whereby for the purposes of securing money advanced or to be advanced by way of loan or an existing or future debt, one person transfer or creates in favor of another a right over the a specified property which is specified in your MOA of the company, E of the company, or documents which you prepared for the register charges created over the assets of the company. That amount must be specified under the head of properties and assets of the company uh, for the purpose of creating charge over the assets of the company. Following assets will be used for the purpose of creating charge. Uh, so that assets, the name of the assets must be specified clearly in the register of charges. Uh, the property to be used for that particular purposes. Uh, this is to be mentioned for the record purposes. So mortgage deed includes every instrument which is used for the purpose of securing money, advance or to be advanced, either by way of loan or an existing future debt, or one person transfers or creates in favor of another a right over a specified property. This is about the difference between the charge and mortgage. They are uh, difference, these two terms. Charge is different from the term mortgage, and the mortgage is basically you just transfer interest in your property, very tangible by nature, to the other person because you obtain loans from that person, and that person, if you're not able to pay that amount, that person can utilize your property for the purpose of repayment of the amount due to you, due to the company or due to you. Uh, that is a case of mortgage. But in the case of charge, a charge is credited over the assets of the company, and that you have to specify. These assets, following assets, will be used for the purposes of crediting charge in order to secure loans and advances from the banks and financial institutions. So mortgage deed includes every instrument used for the purpose of obtaining loans, advances, debts, transfer one person to another person, credits in favor of another person, which is an over the specified property of the company. This is all the major difference between a recharge and mortgage. That is a major difference between these two terms. Charge is different from mortgage, but we use these terms simultaneously. But there's little bit you can see a difference between these two terms, charge and mortgage. Then registration of charges, that is very mandatory for the companies to register their charges as per the Companies Act 2013, Section 77. Under Section 77 of the Companies Act 2013, every company creating a charge shall register the particulars of charge signed by the company and its charge holder together with the instrument created. So this is defined in the particular section of the Companies Act, that every company creating a charge, uh, every company means whether it is a publicly limited company or private limited company, one person company also, charges can be created to in order to obtain per capital for the company. But here it is only mentioned every company. Every company means whether it is public or private. That is not mentioned, but every company. So either public by nature, private by nature, creating a charge shall register the particulars of charge signed by the company and its charge holder together with instruments creating. So important points in the act relating to the charge creation. Any charge created within and outside India on property or assets or any of the company undertakings, whether tangible or otherwise, situated in or outside India, shall be registered. That is a points in relation to the charge created over the assets of the company. That is important points given in in this particular section 77. And point number one is any charge created within India or outside India. That is to be included for the purposes of the registration of charges uh, with the ROC, registered of companies, at the registered office of the company. So this is applicable to every company whosoever registered for the particulars of charges signed by the company and its charge holder uh, together with the instruments uh, creating the charge over the assets of the company. So whether in India or outside India, on property and assets of any of the company undertakings. This is point number two, that is on property or assets or any of the company undertakings. So registration of charges has to be filled, has to be compiled with, has to be submitted to the registrar of companies for the record purposes. You have to keep and maintain files of registration of charges over your property and assets of the company or any of your company undertakings, either wholly by nature, subsidiary by nature. If any charge created over the assets of the company, that has to be mentioned, notified, and as recorded in the records of the company, with all records of the company kept maintained at the register of proper register charges has to be kept and maintained for the purpose of keeping records of properties and assets of the company, whether tangible by nature or intangible by nature or otherwise, whether situated in India, outside India, shall be registered. Hence, all types of charges are required under the Act to be registered, whether created within India or outside India. This is a charge. These are the points to be taken into consideration for the purpose of registration of charges as per Section 77 of Companies Act 2013. All types of charges are required under the Act to be registered, whether created within or outside India. Then come to the application for registration of charge by the charge holder. According to Section 78, as per Section 78 of the Companies Act 2013, where a company fails to register the charge within the period specified above, the person in whose favor the charge is created may apply to the registrar for registration of the charge along with the instrument for created for the charge in form number CHE1 or form number CHE9. So you have to give an application as a charge holder. You have to give an application for the purposes of a registration of charge, and that is to be given by the charge holder who hold the charge. According to section or as per section 78, when company fails to register the charges within a period as specified above, and the person in whose favor the charge is created may apply for the registrar for registration of charges along with the instrument created for the purposes of charge like form number CHE1 or form number CHE9, as the case may be. It is duly signed along with fee. So the registrar may on such application give notice to the company about such application, and the company may either itself register the charges or show a sufficient cause why such charge should not be registered. You have to give your reasons why not able to register your charges with the registrar of company, why not able to keep register of charges. You have to give your explanations in writing and give reasonable cause of not recording the transactions between the company and the banks and financial institutions for the purpose of taking loans and advances. Charge has been created over the assets of the company, and why you not recording the transactions? Why you not recording register, not keeping register as required to be kept as per the Companies Act 2013? Why it is not kept? Company may either itself register the charge or shows sufficient cause why such charge should not be registered. So you have to give reasons, explanations of why not non-recording of charge or the register of charge to the registrar of companies with explanatory notes to that effect. Why it is not registered, why it is not being registered. Then failure on part of the company, the registrar may allow a registration of such charge within 14 days after giving notice to the company shall allow such registration. So on failure of part of the company, the registrar may allow registration of charges within 40 days. And for that, you have to give a notice to the company to that effect and shall allow such registration with the ROC of the company. So any failure on their part, the registrar may allow registration of such charge within 40 days after giving notice to this effect to the company, and that notice allow you for gives you permission for registration by the registrar of companies for the purpose of recording of register of charges of the company. If company not making records, books of accounts, records of the transactions of borrowed capitals of the company, either secured by nature, unsecured by nature, but it must be recorded in the records of the company. If company not recording, then registrar may order the company to after giving notice to the company. The time limit is within 40 days after notice. The company shall allow such registration. That is the time limit for the registration of the charges, its registered charges. After giving notice to the company within 40 days, that is time limit prescribed. Then come to the legality of registration of charges, legal procedures, legal validity, you can say, conformity, you can say, of registration of charges. The charge is registered with the registrar. A registrar shall issue a certificate of registration of charge in form number CHT2, and for registration of modification of charge in form number CLG3 to the company and to the person in whose favor the charge is created. So charge is created with the registrar shall issue a certificate for the purposes of registration of charge in that particular form number CHG2, and for any purpose of modification of charge in form number CHG3 to the company and to the person in whose favor the charge is created. Means like the bank in whose favor charge is created, that has to be mentioned in the registration of charges, in the register of charges by the registrar of companies keeping records where charge is registered with the registrar. Registrar shall issue a certificate of registration of charge in form number CH2 and form number CH3 to the company and the person in whose favor person in whose favor the charge is created. That person is called as the bank. That person is called as the financial institutions. That ensures your legality of your registration charges, because you enter into contract for borrowing of money, loans and advances from that particular institutions, and for that, for the purpose of repayment and of the amount, charge has been created over the asset, so that if the company is not able to pay the amount on time after due reminders, in that then bank can utilize the assets of the company for the purpose of repayment of their dues. So when a charge is registered with the registrar shall issue a certificate of registration of charges in by that particular form number CHG2 and CHG3. These are the form number. You should know as a student of corporate law the form number CHG3, form number CHG2 that is required for the purposes of registration of charges and modification of charges to the company and to the person in whose favor the charge is created. Then the certificate is issued by the registrar, whether in case of registration of charge or registration of modification, shall be conclusive evidence that the requirement of Chapter 6 of the Act, registration of charges, and the rules made thereunder. This is that ensures your legality, that ensures your validity, that ensures the conformity of registration of your charges, ensures your conformity. That gives you a enforceability in the court of law, that all the transaction in respect of registration of charges, in respect of register of charges has been properly kept and maintained by the company, and company can present these documents in the court of law in the case of any dispute, in the case of any non-payment of interest, non-payment of full amount by the company. In that case, the bank can use that particular certificate or charge to be present in the court of law as a mode of evidence, documentary evidence that the charge has been created over the properties, this property of the company, and that charge can be used by the bank because of non-payment of amount due to the company, non-payment of the amount of interest by the company. That gives you validity, and certificate gives you validity and authenticity of your transaction which you enter with the company for the purpose of borrowing of capital of the company. That is secured loans and unsecured loans and advances from banks and financial institutions. The certificate issued by the registrar, whether in case of registration of charge or registration of modification, shall be conclusive evidence, that the requirements of this particular chapter of the Act, registration of charges, and the rules made in this Act for the purposes of registration of creation of charges, modification of charges, uh, whatever the case may be, have been duly compiled with. Further, the Act provides that no charge created by the company shall be taken into account by the liquidator or any other creditors of the company unless it is duly registered and a certificate of registration is given by the star. So, however, this does not prejudices any contract or obligations for the repayment of the money secured by a charge. So the Act provides that uh, no charge created by the company shall be taken into account by the liquidator, official liquidator of the company, or any other creditors of the company unless it is duly registered. That makes your charge valid. You can enforce in the court of law. If there is a non-payment of dues by the company, then the banks can utilize this certificate of charge in the court of law, present in the court of law, and can uh, utilize that property and assets of the company for the purpose of payment of their dues. So, it must be duly registered. Otherwise, suppose there is no charge created over the assets of the company, taken into account by the liquidator or any of the creditors of the company, unless it is duly registered and the certificate of registration is given by the registrar. So it must be registered, otherwise no charge created by the company shall be taken into account by the liquidators, any other creditor, unless it is duly registered and certificate of registration is duly given by the registrar, that is legality of the charges. Uh, that gives you obligation because it is registered in the register of charges and it is a copy is duly submitted to the registrar of companies for the record purposes. That it does not mean that any contract obligations for the repayment of money secured by a charge. So this gives you a legality. This gives you validity of your registration of charges. It must be registered at registrar of companies for record purposes, for obtaining of loans and for obtaining loans advances with the banks and financial institutions, for making repayments on loans advances to banks and financial institutions with interest. These registers has to be kept so that you have valid records and proof that you have entered into transactions with that particular bank or financial institutions for the purposes of repayment of the money secured by a charge. Then come to the point procedure for registration. And if a company has passed special resolution in the meetings of the board directors of the company, and that authorizes you for the purposes of registration of charges by the company for the purposes of securing loans and advances from banks as per section 180 subsection 3 subsection C of the Companies Act 2013, that authorizing the company by its board of directors to borrow funds for the requirements, for the purposes of the company, to finance the projects of the company, to finance the ventures of the company under section 180 subsection 1 clause A of the Companies Act 2013, and that authorizing you as a board of directors to create a charge over the assets properties of the company, to provide securities for repayment of borrowings in favor of the financial institutions, banks or lenders, and in exercise of that authority that has signed the loan documents. So, for the purpose of obtaining loans and advances by creating a charge over the assets of the company has to pass, as per the process involved, the company has to pass a resolution that is special by nature under section 180, subsection 3, subsection 3, clause C of the Companies Act 2013, that authorizing the BOD of the company to obtain funds for the company, for the requirements of the company under section 180, subsection 1A of the Companies Act 2013, that authorizing the board of directors to create a charge over the assets and properties of the company and to provide securities for the repayment of the borrowings in favor of the financial institutions, banks, and lenders, and in exercise of that authority that has signed the loan documents and now processes to charge created by registration with the ROC. So meaning is that keeping and maintaining of records, and that is very important. That and signing of the records by the BOD of the company, that makes your documentary evidence valid. Otherwise, it is invalid in the court of law. Uh, so Companies Act authorizing BOD or the company to create a charge over the assets of the company, properties of the company, and to provide securities for the repayment of debts of the company due to the company in favor of banks, in favor of your lenders, in favor of your financial institutions, and exercising of that authority has signed the loan documents and proposes to have charge created by its registration uh, with the ROC. That makes your document valid document, confirmed document, because you registered your register charges with the registrar of companies and paid the registration fees for the purpose of registration of charge creating over the assets of the company with the ROC. And for that purposes, you have to pass a special resolution to make it to effect to the register of charges under section 180 of the Companies Act 2013, form number MGT 14 of the Companies Management and Administration Rules 2014, is to be filed with the registrar. So this is about the procedure involved in registration of charges, and for that procedure, you have to pass a special resolution. Means at least 75% of the majority should be with the resolution to be passed in the meetings of the company, and that gives authority to prepare and create a charge over your assets and properties of the company, undertakings of the company, either whole by nature or subsidiary by nature or affiliate by nature. So you can create a charge over your properties by having taking a resolution and the board meetings of the company, general meetings of the company. It has been passed, must be passed, that to make it to affect implementation, for the purpose of implementation, executions of the uh, certificate of charges, or for creating charge over the assets of the company. Uh, so procedures, this is a procedure involved for the purpose of registration of charges, and with the special resolution is passed as required under section 180 of the Companies Act 2013, form MGT 14 of the Companies Management and Administration Rules 2014, is to be filed with the registrar of the companies. Then come to the term register of charges. Section 85 of the Companies Act is about the register of charges, and that section, the section of the Companies Act 2013, provides that every company shall keep at its registered office a register of charges in form number CHG 7. This is section 85, that every company shall keep its registered office or register of charges in form number CHG 7, which shall include in all charges and floating charges affecting any properties or assets of the company or any of its undertakings, indicating in each case and such particulars as may be prescribed uh, by the company. So you have to make a record including all charges, whether fixed by nature, floating charges, that affect your assets, that affects your property of the company or undertakings of your company, or any such particulars of the company as prescribed in the for the purposes of the registration of charges. Register charges has to be maintained and kept in accordance with the form number CHG 7. The entries in the register of charges maintained by the company shall be made forward with after the creation of charges, modification of charges, or satisfaction of charges as the case may be. Then come to the consequences of non-registration of charges. There are certain consequences which have to bear due to non-registration of charges, as required to be and you're not able to keep the register of charges with the company. Then in that case, you have to bear the consequences of non-registration of charges, as per section 77, or you can say according to section 77. Of the Companies Act 1956, all types of charges created by a company are to be registered by the ROC. And where they are non-compliant and are not filed with the Registrar of Companies for the purposes of registration, it shall be void as against the liquidator and any other creditors of the company. This is section 77 of the Companies Act 1956. All types of charges are created by a company, whether it is fixed by nature, floating by nature, and it is to be registered with the ROC. If it is not registered, then you have to bear the consequences. And where they are non-compliant and not filed with not comply as per the provisions of the Companies Act, section 77 of the Companies Act 1956, not comply with the provisions of the Act, not filed with the ROC of the company, for the purposes of registration of charges, that transaction shall be declared void as against the liquidator and any other creditors of the company. But this does not, however, means that um, because the company has to pay to the creditors of the company. Company receives from their debtors, but company has to pay to their debtors. If company not register their register of charges, in that case, for that particular transaction, that transaction is declared void by the court of law. If there any complaint filed by the bank's financial institution in respect of the repayment of the amount due, but it is not registered, it is not a valid transaction. It is void. If we are going to enforce it in the court of law, it is declared void, and any other creditors of the company. So this is section 77 of the Companies Act, that is about the consequences of non-registration of charges, and this does not, however, means that the charge is altogether void. We can make it a rectification, we can make it correct, confirm, and if debt is not recoverable. So this does not, however, mean that charge is altogether void and debt is not recoverable. So meaning is that it can be recoverable. That is a question. The debt can be recoverable by the banks and financial institutions if company ratify and make it confirm valid the register of charges for that particular assets or property of the company. So long as the company does not go into liquidation, the charge is good and may be enforced. Then come to the consequences, again the continuation of the consequences of non-registration of charges. And it is already declared void in the court of law if you not register your charges with the registrar of companies and not keeping records of register of charges. And it is declared void in the court of law against the liquidator. Means that liquidator owns the income of the company can ignore the charge and can treat the concerned creditor as unsecured creditors. Okay, that is the meaning of this line. This is to be noted down by the students that in the case of winding up of the company, in the case of liquidation of the company, in the case of dissolution of the company, in that case the company can, if it is not recorded, there is no record of such transaction, that is we company with the bank for the purposes of borrowed capital of the company, then company can ignore the charge and can treat the concerned creditors as unsecured creditors of the company, and the property will be treated as free of charge. There is no charge created over the asset of the company, and the creditors cannot sell the property to recover its dues. So it is void against the creditors of the company, means that if any subsequent charge is created on the same property and the earlier charge is not registered, the earlier charge would have no consequences and the later charge at the register would enjoy priority. That is the case may be. So it is void against the creditors of the company and means that if any subsequent charge is created on the same property or assets of the company, the earlier charge is not registered and and would have no consequences, and the later charge, if registered, would enjoy priority. So holder have a right, can have the property sold in order to recover its money.